our participants are here. Let's see. Got Mr. Crancer. Mr. Clem. Well, good morning, and I'd like to call this forum to order this morning, the Clean Air Act Forum, State, Local, and Federal Cooperation in the Clean Air Act. Many of you are aware that this is the third forum that we've had on this subject matter, and we did not want to have congressional hearings per se because we wanted these forums to be totally, I wouldn't say, we want it to be free-flowing information, and we want people to feel free to interrupt at any time, to raise any issue that they would like to raise. And we've had good attendance at all of these forums, and the purpose, of course, is for us to listen to the people who on a daily basis are dealing with the Clean Air Act through the state implementation plans, through all of the conferences, the relationships with the federal EPA, the companies involved, the businesses involved, and so forth. And each one of you, we're going to go around the room. I'm going to introduce everyone, and we have the news media in the back, and we feel like they're being isolated back there almost because they're so far away, but we've had good attendance from the news media, and we've had, I think, fair coverage on it as well. And to emphasize the informality of this forum, that's why you see those cookies and almonds there on the table, so that hopefully you'll feel more relaxed. So with that, we'll have members coming in probably on and off throughout the forum. Some of our Democratic friends are actually having an organizational meeting this morning, which some of them indicated they'll be coming in as they are able to do so as well. So I want to welcome all of you. Thank you very much for attending. We think it's very important that we do have these forums because we really have not explored, reviewed, or thought very much about the Clean Air Act for many years. And as I said in the beginning, each one of you participants are intimately familiar with it. You deal with it on a regular basis. And so this is a listening session for the members of Congress who have responsibility and jurisdiction over the Clean Air Act. And like I said, members will be coming in. There's David McKinley and Morgan Griffith. There's a chair up here, Morgan. So now at this time, I'm going to introduce our participants. First of all, we have Ms. Martha Rudolph on my right, who's the Environmental Program Director at the Colorado Department of Public Health and the Environment. We have Mr. Michael Crancer on my left, who's the Secretary for the Pennsylvania Department of Environmental Protection. We have Mr. Robert Martineau, who's the Commissioner from the Tennessee Department of Environment and Conservation. We have Mr. David Klemp, who's the Air Director for the Montana Department of Environmental Quality. We have Mr. Jason Halter, who is a counsel with Aiken, Gump, Strauss, Hauer, and Feld, who's testifying today on behalf of the Gila River Indian community. They had intended to, some of them had intended to be here, but due to circumstances, were simply not able to be here today, so their counsel is going to be testifying on their behalf today. We have Mr. Sayed Sadruddin, who is the Executive Director, Air Pollution Control Officer for the San Joaquin Valley Air Pollution Control in California. And then we have Mr. Arturo Blanco, who's the Pollution Control and Prevention Bureau Chief for the Houston Department of Health and Human Services. And we have Pete Olson, who's a member of Congress from Texas. We have Mr. Mike Pompeo from Kansas, Tim Murphy from Pennsylvania, Morgan Griffith from Virginia, Dave McKinley from West Virginia, John Shimkus from Illinois, and I happen to be from Kentucky. But anyway, so I want you to feel free if one of the other participants is making a comment and you have a question, just I hope they won't mind. You can just say, would you clarify that or whatever. So as I said, our purpose today is to listen to you and to ask that you give us your experiences with the Clean Air Act. And we know that it's been a successful act. We're very fortunate that we have very clean air in America. We want to keep it that way. But we also know from the two previous forums there are some real concerns. And just to give you one example, without going into great detail, we've had many of the states have come to testify that it's really a problem for them when third parties bring lawsuits and then the EPA makes a settlement with that party, even though it may affect a state, and that state's not really involved in the settlement discussion. So that's just one example. But I'll tell you what we'll do, if Martha, if you don't mind, and hope you don't mind my calling you Martha, we'll start with you, and what we'll do is ask each one of you to take, maybe 4, 5, 6 minutes just to give us your perceptions and how things are going for you and your responsibilities on the Clean Air Act. So we'll introduce at this time Martha Rudolph.
Thank you. Thank you, Mr. Chair and members. To be here today, there you go, thank you. Failed to turn on the microphone, that doesn't work very well. Again, thank you all for inviting me to share with you Colorado's perspective on our relationship with EPA and our work under the Clean Air Act. We appreciate the opportunity to be here. First of all, let me say that Colorado enjoys a good, solid working relationship with EPA, both at the Region 8 level and at headquarters. We are fortunate, and I do mean fortunate, to have Region 8 headquarters in Denver. It makes it much easier for us to meet with officials from EPA face-to-face and to collaborate and work out issues, and we do that quite frequently. By the same token, we also have worked closely with folks from headquarters. We have video conferencing, and they do come out on occasion and are always accessible. So we very much appreciate that. You've already mentioned, Mr. Chair, that I think there's general consensus that the Clean Air Act has been very successful. The last 4 decades of implementation have resulted in significant success in cleaning up our air emissions throughout the country, and so I won't belabor that. But I think we've all acknowledged that the low-hanging fruit is gone, and so it becomes much more difficult to really do more to clean up our air. Part of this we see is because of population growth. Obviously, with more people comes more impacts to air, and actually more receptors that are closer to air pollution sources. Air quality standards are becoming more stringent. You've heard that before. Cross-boundary emission impacts are also becoming an issue that we need to look at within states and regions. States as big as Colorado or Texas, for example, you're going to have a lot of internal issues with boundary disputes, or not boundary disputes, but emissions going from one area to another. Certainly it's the case with from state to state and even internationally. This is something that we're going to have to grapple with. So there is a greater need for collaboration. One thing I will mention in Colorado, as other states have experienced, new technologies have allowed industry to go into areas that before did not occur. What I'm really speaking about here for Colorado is the oil and gas industry, with the ability to extract oil in particular in Colorado in areas that before never experienced this industry. We're having a definite increase in the number of oil wells on the Front Range in communities, large communities, Denver, Boulder, Fort Collins down into El Paso, Colorado Springs, that never experienced this kind of industry before, and so with that comes air quality issues that we're having to grapple with. So there's a greater need for collaboration in addressing air quality issues. We need to work together with EPA, with local governments, with the states, with the regulated community to come up with creative ways to deal with our air emission issues that we're facing now. We need to look at multi-pollutant controls. You've heard that before. In Colorado, we have done that, worked very cooperatively with regulated community, with the electric utility, with the natural gas operators, with the legislature, with the environmental groups on our Clean Air, Clean Jobs Act, which we passed a couple of years ago, which really looked at existing and potential regulations coming down the pike to really look sort of globally at how we can address and control those multiple pollutants, and that's been a very successful activity. We also need to collaborate, I think, on cross-boundary issues. I've mentioned that. And we need to collaborate to fully understand the impacts, requirements of new control strategies as they come down the pike. And this is something that we're really interested in. This is looking at when EPA promulgates new regulations to make sure that it issues guidance at the same time that it issues the new regulations. We think that this will clarify for states at the time that the regulation is adopted, at the time, for example, that a new national ambient air quality standard is adopted, so that states really have a better sense for how to affect the changes, how to look at the issues to be able to come up with regulations that EPA would accept. And we also think that what it does is it gives EPA the benefit of really understanding how the regulations will impact the regulated community, will impact state and local governments. We'll get a sense for how it can be implemented, the new regulations. And so we think that collaboration and work to get guidance out at the time the regulations are adopted is critical. And we know that there's activity now to try to pursue that. So we're happy about that. There are areas where more collaboration and cooperation are needed. We've had disagreements with EPA over the legal interpretation of regulatory requirements. Again, this kind of gets back to when a regulation is adopted and guidance guidance is not adopted at the same time. There's a gap there so that states are left trying to figure out how to, or on their own, to come up with strategies to implement whatever the new requirements are. Often it's the National Ambient Air Quality Standards. And if the states get it wrong, then you have a debate with EPA over legal interpretations. And this is often the case where the regulations are less than clear and are capable of multiple interpretations. And so what has happened to us is we've, again, gone downtown to Denver and had numerous meetings with EPA, and eventually have been able to work it out, which is good. But ultimately, if states are not able to work it out, there's no dispute resolution, really any kind of formal dispute resolution. But I think, in our experience, EPA at the regional level and at headquarters, we've been able to work things out, which is good, but it does take resources and time to do that.
Would you be able to give us maybe a specific example of just one issue that you dealt with relating to this problem?
Certainly. When we were working through our regional haze SIP, I think that's one where a number of states had issues with EPA on exactly what EPA wanted, and part of that is because of the passage of time, and so people at EPA change and perspectives change. But we had submitted part of our regional haze plan, our SIP, to EPA, and EPA had some significant issues with it. We were able to work them out, but again, it took several months going back and forth before we were able to do that.
Yeah.
A related issue, National Ambient Air Quality Standards. I think you've heard the concern about whether or not the standards should be revised every 5 years, or whether that period should be extended. I'm not convinced really that extending the time period beyond 5 years at least initially, is the answer. I think that there's so much that the states have to do and EPA needs to do within that 5-year period, that's what the problem is. So if we were to get together tonight, and again, there are groups that are working on this, ECOS and others, to look at really the process of reviewing SIPs and approving them, I think if we were to really look at efficiencies that can be gained there and try to work those out, that would be the first step that I would recommend taking internally before we really look at extending the time for reviewing national ambient air quality standards. A couple of other really quick points I would point out. EPA often focuses its attention on coastal states, which I'm very happy with that. That's fine with me. but there are differences between the states, all the states. For example, Colorado is a high altitude state. Ozone background levels can be as high as 50 parts per billion in Colorado just simply because of the altitude. And so that's we're going to face a different issue there. Also, states in the West have a phenomenon called, we're referred to as rural ozone. Fortunately, Colorado does not have this issue, but there are others that do, and if the standard is lowered, we might. What I mean by that is there are areas in states that are in non-attainment now for ozone, and so the states need to come up with strategies to reduce the ozone emissions to meet the standard, but there are no sources in these rural areas, no sources for ozone. This, again, sort of talks about the transport of emissions from one area to another, which is going to require a fair amount of collaboration of many people to address this issue. Colorado is also an arid state. We have lots of dust issues that I think are greater than they are in the more humid or the coastal states. And in the West, wildland and prescribed fire, smoke impacts represent an enormous challenge for us in managing air quality and protecting public health. We've all heard about all the wildfires that have been in Colorado and throughout the West, and that's an issue for all of us. And then finally, I'll just say that resources is an issue. Everyone is facing resource issues, and I think it's incumbent upon EPA when it is looking at imposing additional requirements on states that it really consider what the cost is to the states to implement those. And this again underscores the need to have upfront collaboration with EPA to really come up with efficiencies and what those regulations should be, what the goal is, and how to really achieve the goal in the most effective and efficient way. And so those are my remarks. Thank you.
Well, does EPA consider costs to states at all, or do you know?
I think it does. Certainly in the establishment of the National Ambient Air Quality Standards, it doesn't. Yeah. And I think that's appropriate.
Right.
But when you're looking at the strategies to implement the National Ambient Air Quality Standards or other regulations, I think EPA does look at the costs. I couldn't tell you in what the internal discussions are at EPA, but I think at some level they do.
Well, Martha, thanks very much. And Corey Gardner has come in since you know Corey from Colorado. Yes, did you want to make a comment, Corey?
Oh, no, I just wanted to welcome Ms. Rudolph, excuse me, to the committee today, and second her remarks. I think Jim Martin, although we have at times disagreed on some issues, I do think Region 8 has done a good job in Colorado in terms of working with the state and others throughout the region. So thank you for being here, and look forward to asking you some questions and getting in this a little bit more. Thank you. Welcome.
Yeah, and Corey, I think you came in just a little bit late, but I also indicated that we want everyone to feel free to ask a question at any time. So don't hesitate if you want us to do it.
Well, if you don't mind, I would ask a question a little bit to follow up, if you don't mind.
Sure, absolutely.
Thank you, Mr. Chairman. And Ms. Rudolph, you did mention the SIP. And I know Jim Martin, Region 8 Administrator, has been supportive of the SIP. It's received bipartisan support. The entire Colorado congressional delegation, Senate and House, Democrat, Republican, have supported this SIP, but it still hasn't been published in the Federal Register. Do we have any idea when that is, if that's part of the process that could be improved upon, how we could improve upon that?
Are you speaking about the regional haze?
Regional haze, I'm sorry, yes, yeah.
That is a good question. I'm not sure what the timing is for the publication of the SIP. I know that they've approved it, but it still needs to go through that publication, and I can find that out for you if you
Okay.
would like me to.
Good, and that's just one of the concerns we had. You also mentioned, and I think when growing up in Colorado in the Eastern Plains, you know, the brown cloud in Denver, you could drive over the Akron Hill, which was 120 miles away from Denver, and you could drive down into the infamous brown cloud. You don't see that as much today as a result of the work that the state has pursued over the past decade or more. But this summer we did see, I mean, it was incredibly ugly at times with the air quality in terms of the wildfires. As a result of those wildfires, what happened at the EPA? Were there actions taken, things that we need to watch out for?
Thank you. Wildfires certainly have an impact on our SIP and our attainment. And that you're bringing up really what's called an exceptional event, so that when you're monitoring air quality and you've got an event that is, it's sort of the but-for test. But for this exceptional event, you would be maintaining the standard, the air quality standard. So when a state is turning in its data to EPA, it can make a case that an exceedance of a particular standard, ozone or PM, is the result of fire, for example. The problem with the exceptional event is that EPA rarely will process an exceptional event request. It takes a lot of data and a lot of information, and it's a lot of work for states to try to make the case that but for this exceptional event, you would have maintained the standard. That's an issue that we have with EPA, and we've requested that EPA move quickly on looking at exceptional events. What we have done is often is that we will see over the course of the summer, for example, what our ozone levels are, and if the ozone levels are such that we would have not triggered a violation, we may not even file an exceptional event request just because of the effort it takes to do that. It has taken, I mean, there are many filings that we've had with EPA on requesting an exceptional event that EPA has not acted on, and that is of concern. And I think it's in part because EPA is not quite sure exactly what it takes to demonstrate an exceptional event, what really the facts need to be. So we've urged EPA to work on this and to really come up with something, because I'm sure other states have the same issue that we have.
Okay, Steve Scalise just came in from Louisiana, and Steve's also the new vice chairman of the Energy and Power Subcommittee, and I look forward to working with you on that, Steve. Michael, how about you? Would you mind giving us your perceptions and thoughts on this issue?
Sure. Let me give just a first shout out.
Let me just say, first of all, I'll say this again. Michael Kranzer is the secretary for the Pennsylvania Department of Environmental Protection. I'm doing that primarily, Michael, because of the news media in the
Sure,
background.
no problem. As I said, I want to give a shout out to Representative Whitfield for having the courage to have these forums or fora. They're a great idea. I happened to meet the congressman when he came to my neighborhood in southeastern PA and met with a bunch of stakeholders, and he showed then his real statesman-like presence, and I think this is a testament to that. Another thing I'd like to do is recognize the historical moment in this room. We have two 1983 Washington and Lee Law graduates sitting right next to each other in the halls of Congress. Which is good news for Washington and Lee, should be very good. I was joking with my friend Morgan here, should be very good for recruitment in the next few years to have this on television and in the press. But going on to the subject at hand, I want to hit some overview topics, and then I know we'll get back to them as time goes on. Clean Air Act is clearly a success by any objective and every objective standard. We have cleaner air in America than we've ever had before, and probably cleaner than anywhere else in the world. I am a firm believer that the Clean Air Act is not a good tool to regulate greenhouse gas emissions. It is being tried. It is not working. It is awkward for that purpose and should not be used for that purpose, especially when Congress has already said that's not the way we should go. Natural gas production, and we touched on that before, is a way, perhaps, that this country can attack the greenhouse gas emissions issue. Our country is showing dramatic reductions in greenhouse gas emissions, and it's because of our increased use of natural gas as a fuel. Cooperative federalism. We've heard and read a lot about cooperative federalism in the Clean Air Act. The Clean Air Act requires cooperative federalism. The Constitution of the United States requires cooperative federalism. We are not seeing today cooperative federalism in any way, shape, or form, and this is not Mike Krancer saying this, although he is saying this. It's the D.C. Circuit Court. It's the Fifth Circuit with the Texas Flexible Permit case, which Representative Olson is very familiar with. It's the Sixth Circuit case in Summit Petroleum with an air aggregation decision. So we have courts of the United States blowing the whistle on what they see. And if you read these opinions, and I'm a former judge, I love to read opinions, and I love to write them when I wrote them. Read these opinions, and you really get a flavor for what these courts are thinking about that. There's some very colorful language in many of these opinions. SIP approval. SIP approval is too slow. We had a weird situation in Pennsylvania where we had a SIP sitting on EPA's desk for years and years and years. We as a state already implemented, had a regulation, because that's what SIPs do, they're regulations. A group in Philadelphia, the Clean Air Council, petitions EPA to hold Pennsylvania in contempt, sanctions left and right for doing this horrible thing that was all agreed upon in the SIP, it just hadn't been approved. And when I looked in a catalog, I saw that the Sierra Club, another NGO, was actually suing EPA for delaying in approving this particular SIP. So it's sort of they got you coming and going on this. We need to move quicker on SIP approvals. Transport issues are not handled very well by the Clean Air Act as it's structured right now, and we've gone through 2 different circuit court cases that I think demonstrate that. We probably need some view or some review of a legislative potential fix for that. Trading is a fix that can be used for transport issues, but that's been a sticking point with a few circuit courts. State permitting in my state is perfectly fine. We're getting the permitting done. We're getting it done on time. There is a federal overlay sometimes that causes confusion and causes delay. NACs, Ms. Rudolph touched on that. What we're seeing, I think, under the Clean Air Act today, and really the Clean Air Act is a tool. You can liken it to an automobile. It has a great purpose. It can be used for great uses, but you have to use it responsibly. And that probably goes as an overarching theme to everything I've said and everything I will say. We've seen really what I would call a NACS activism in the last 3 years, in the last 3.5 to 4 years. And if you just look at the numbers, you'll see that in the first 3 years of this EPA, they have changed or announced changes in 4 out of 6 NACs. That is more than the 8 years of George W. Bush and the 8 years before that of Clinton. So in the first 3 years, there's been more NACS activism than there had been for 2 previous presidents. I would also make a pitch for the requirement of science-based regulations and for good, real cost-benefit analyses in regulations that call for cost-benefit analyses, not trumped-up ones, not double-counting ones, not ones that are really smoke and mirrors. Real science-based regs with real cost-benefit analyses behind them. And with that, I would just like to, again, thank the Congressman for having this forum, and I'm sure we'll get into more detail on all these topics as the forum continues.
Well, thank you, Michael. What we'll do, we'll go on and try to get the other participants, and then we'll have this free flow of discussion. Mr. Robert Martineau, Commissioner, Tennessee Department of Environment and Conservation. So, Robert, you're recognized.
Thank you, Mr. Chairman, and thank the members of the subcommittee for hosting these forums. I, too, want to acknowledge and congratulate you on holding these forums, and this is the 3rd one. It's really an honor for me to be here with my distinguished colleagues to talk about how we can improve that cooperative federalism that is a fundamental part of the Clean Air Act. And I, too, will second what others have said, is that the Clean Air Act has, by and large, been a tremendous success over the last, since 1970. We do have cleaner air today than we've ever had. We've virtually eliminated lead emissions and have had substantial reductions in most of the other criteria pollutants, despite significant economic growth, significant growth in our economy, and significant growth in vehicle miles traveled. So for that, there's much success. I've had the privilege over the last 25 years, almost 30 years now, of practicing in the environmental law area and with a particular specialty in the Clean Air Act. And I've had the opportunity to see it from several different perspectives. I spent 7 years at EPA in the Office of General Counsel working on Clean Air Act issues. I've practiced in private practice representing large and small clients in the Clean Air Act area and other environmental issues for almost 20 years, and for the past 2 years almost now as a state commissioner. That prepared me for some particular insights from the different perspectives of that. And I'm fortunate in Tennessee we have over 100 air pollution professionals led by 2 folks that have more than 80 years of combined experience in Clean Air Act. So we have seen in Tennessee really the Clean Air Act evolve over the last 30 years. And I too wanted to acknowledge that for the most part we have a very constructive working relationship with EPA, particularly those in Atlanta. We often disagree over the process and sometimes the outcome, but for the most part we've been able to keep a very open and constructive dialogue. And I think we need to recognize that positive part of what we've done as we look at opportunities for improvement. In 1969, Walter Cronkite named Chattanooga, Tennessee, the dirtiest city in America. We had leaded gasoline, we had smog filling the cities, and through the good work of EPA and the states and the local programs working with the regulated community, we've made dramatic improvement. At the same time, we've fostered economic development. Yet there are many changes. I've submitted detailed responses to the questions you posed to the committee, and I'll highlight just a couple of the things, some of which others have noted. Under the cooperative federalism approach, under the structure of the Clean Act, clearly EPA has the job for setting the NAAQS. That's a national scientific-based standard that they're best suited to do rather than each state trying to figure out. We don't have the expertise to do that. But in that cooperative federalism approach, the concept of the Clean Air Act was that the states would have the flexibility and the ability to design how to meet those NAAQS to reflect their particular circumstances. And I think as time has evolved, that flexibility and freedom for the states to implement what they see as the best provisions of to develop a SIP have become more and more constrained, and it's been more and more prescriptive, sometimes through policy, sometimes through just constraints that were built into the statute through various amendments as the amendments became more prescriptive as to what had to be in SIPs, particularly with ozone. So I think there's some improvements that we can look at that. I think we're going to have a real challenge, as Martha said. We've gotten the low-hanging fruit. Real challenge as we look at these NAAQS and as they get down to near background levels or scientific data that suggests that virtually no emissions are acceptable. There's no threshold. We simply, we can't have a standard that says no emissions are acceptable. We deal with risk in many other contexts in our lives every day in riding airplanes and driving on vehicles on the road, and we've got to find that right balance that we can have a society that fosters economic development and our lifestyle, but still protects public health. The timing and cycle for NAAQS, we are caught in a virtual do loop. The NAAQS, if you revised it every 5 years, you don't even have time to implement through the SIP process the requirements for one before the next. As the scientific process becomes more complicated, we probably ought to look at lengthening the time for review of that NAAQS to allow an implementation period when you set a NAAQS before you start on the next one. And so the current 5-year cycle is probably too short. And then the further complication with the multiple NAAQS, and particularly troublesome, is those pollutants that are not directly emitted, like ozone, where you're really looking at precursor pollutants. And a specific challenge for many is ozone. In the southeastern United States, ozone's formed by both VOC emissions and NOx emissions. In different parts of the country, one may drive versus the other. In the southeast, it's really NOx driven. Yet the statute and the reasonable further progress requirements under the Clean Act require a 15% reduction in VOCs. In Tennessee, we had the example, we looked and did the scientific study to show that further reductions in VOCs would not really help us move towards attainment of the ozone standard. So we offered to EPA substituted additional NOx reductions as part of our SIP, and EPA did not want to accept that because they said they were the statutory restriction on the 15% reasonable further progress. It's really hard to tell regulated industry that they have to make 15% reduction and invest millions of dollars in VOC reductions when we have data that suggests that's not going to help us achieve the ozone standard. That's a real challenge that needs to be fixed. And that one-size-fits-all approach is where we've lost some of that fixed flexibility to design.
Do you have an appeal process in a situation like
I think the answer, I mean, we could have challenged the SIP, that the answer was basically, well, that's in the statute, and they're right, you know, on that sense. But there was the lack of flexibility to say, here's an alternative that gets you the same result, because the result is what we would have been looking for. And so we need to find better ways to tailor those controls. Another opportunity to flexibility, and I think this has been mentioned in some of the earlier forums. In 2002, 33 states submitted early action compacts to help reduce ozone, where they agreed to make reductions earlier through a series of voluntary measures and other measures to meet the 1997 ozone standard. They signed early action compacts, and in exchange, EPA said we'll defer essentially the effective date of the non-attainment designation, so you don't have non-attainment new source review and offsets for new sources to allow communities the opportunity for continued growth. That program worked. We got, in Tennessee, a number of our communities participated in that early action compact, and those communities that did got cleaner air sooner. And this current time around, EPA backed away from that and said that they did not see the statutory authority for providing those allowing those early action compacts. So everybody agreed it was a good result. We actually got cleaner air sooner. We gave more flexibility to communities to not have the non-attainment stigma attached to it. Yet we didn't, in this go-round, EPA has chosen not to allow that process to move forward like it did in 2002. It's another example. The SIP process, another thing I'll mention briefly, others have alluded to, it takes too long to get the SIPs reviewed and approved, and it's a cumbersome process. First, as everyone has alluded to, the SIPs are really mostly state regulations that go through a state rulemaking process that EPA can participate and comment on, and they most often do, and often provide very helpful comments as we refine the rule at the state level. And then it goes to EPA again for another review process. And just to give you a sense of the backlog, and ECOS and others are working with EPA to try to expedite that process, but it really is cumbersome and broken. We currently in Tennessee have 21 SIP submittals that have been sitting at EPA for more than 2 years. 10 of those 21 have been there for more than 5 years. That's a system that inherently doesn't work well if we have that kind of backlog, because as Michael alluded to, the regulations are adopted at the state level. The regulated community, the public, think those regulations are in place, but some citizens group or EPA can come in later and say, well, no, they're not approved by EPA yet, so therefore you have to comply with whatever the old SIP was that EPA had approved, as well as what the state law had changed to be, and people can get caught in between those two requirements. So that's a system that needs to be addressed. And at some point, you know, and maybe we should look at deadlines, that if EPA doesn't approve a SIP within 18 months or so, then it ought to be assumed to be approved or approved by default, because they really have two steps in that process. And what it also breeds is people can sandbag the issue. If a citizens group or other people have an objection to a SIP as it's going through the state rulemaking process, they can sit back and stay quiet and wait till it goes to EPA and raise the issue later. So the state, during their rulemaking process, never had the chance to address the issue that might have been raised once it gets to EPA.
What would be the cause for delays of that length?
A lot of it is workload and priority, and sometimes I think there's some passive aggressive. If there's SIPs that may be approvable but maybe not exactly what EPA would have liked to see in the rule, they'll sit on it. where there's, if, we're pushing through a NOx SIP call or something that EPA, where the SIP is really parroting exactly federal requirements, they tend to go through faster. But if we're trying to do something that doesn't quite fit in the square box, those sometimes lead to the delay. And some of it is, frankly, just workload. It's not seen as a high priority because it may be a source-specific SIP provision or applied to only a few sources, so it gets a lower priority given the limitations on workload. Another problem area that is really the area of new source review. We need a permitting system for sources that is consistent and clear and timely. And the new source review initiative undertaken by EPA literally went back 25 to 30 years and looked at permits and changes that had been made at facilities across the country that had been permitted, that had been inspected by the states, that had been inspected by EPA over the years, and then retroactively said you should have put pollution control devices. Now, I'm not arguing that controls shouldn't have been reduced or that we shouldn't look at ways through regulatory requirements or otherwise to reduce those emissions. That's not what I'm talking about. It's that we should not make decisions on whether or not to reduce emissions through a retrospective 25 or 30 year later process. The only people that really benefited from that are lawyers and expert witnesses. And I've seen this from all sides. As I said, I was at EPA working on new source review issues. I represented clients on new source review issues, and now as a state program. And what it breeds is uncertainty that even once you get a permit, you don't know for sure that you're going to not be asked later, not be held accountable later for somebody else later determining that your project should have gone through new source review. And that system does not work well. It doesn't give anybody any certainty. We get requests all the time. Regional offices get requests at EPA all the time for, tell me what's a modification or what's a routine maintenance project. And the answer varies literally every day. There's no consistency. It varies. The decisions on what's routine maintenance are often made by what's the litigation posture of EPA in a particular case at that time, and the number of guidance documents and the number of applicability determinations. No person can discern what that test is on any objective way. So we've got to find some way to make that permitting system better and decide how we move to an easier test, whether that's an hourly based emission test, whether it's just setting a review every certain number of years that you look and say, should controls on these facilities be upgraded based on current technology or whatever. But the current system really needs to be explored because this regulation by litigation and determining 10, 15 years, 20 years later that this project should have gone through new source review is dysfunctional. So those are the main points I want to make. The other one you alluded to earlier that had been commented on is the committing obligations to the states through citizen suit settlements, where EPA and a citizens group agree through a settlement of a citizen suit to require states to change their SIPs or issue permits or do something. And the states are not involved in those litigations. Sometimes states have tried to intervene and not been successful in that because one of the parties did not want them at the table. There needs to be a way, and I know that the House has passed a bill to address some of that, and that kind of fix needs. It's not Clean Air Act specifically, but that kind of fix it's been most problematic in the Clean Air Act because of the number of citizen suits around the Clean Air Act, although that position would apply across the environmental statutes. So those are some of the key points, and we can discuss further some of those issues.
Can I jump in and make one quick observation, just following up on what you said? There's an irony in that I think it's a can't means won't situation. We have SIPs that sit for years and don't get approved, but we have an EPA that is very prolific in its regulation writing. And I think we have more pages of regulations than we've seen in history. So we have a regulatory side of the House that's very, very busy doing a lot of work that we see every day in the Federal Register, but a SIP side of the House, a SIP approval side of the House, and a permitting side of the House that is basically dormant. You can hear a pin drop in there. And that gets to this bigger issue of is and should, and I think it should not, air policy be translated into national energy policy. I mean, the bottom line is it's called the Clean Air Act, not the National Energy Policy Act.
Okay. All right. Thanks very much, Robert. At this time, Mr. Klimp, David, by the way, is the Air Director for the Montana Department of Environmental Quality. And David, we look forward to your comments.
Thank you, Mr. Chairman, members of the committee. Again, thank you very much for having this forum, for inviting me. This is a unique opportunity for a kid from Montana to come to Washington, D.C. and discuss air quality matters, and I'm hopeful for a very rigorous discussion. I try to engage my wife and kids in the intricacies of new source review and increment consumption and state implementation plans, and I'm just not met with the same sort of connection that I am in this room. So thank you very much. First of all, my goal today is to just give the subcommittee a sense of Montana's experience in implementing the Federal Clean Air Act. Montana also has a Clean Air Act of its own, the Montana Clean Air Act, and it predates the Federal Clean Air Act. And in fact, Montana's got a rich history of air quality issues, air quality discussions, and air quality resolution. Throughout its history, Montana has been steeped in natural resource development, starting in the western part of the state, both with timber, copper, silver, gold. I say copper first because generally in Montana, copper has been king. And now heading into the eastern part of the state, there is a tremendous amount of oil and natural gas development. And those developments have not occurred without creating some air quality issues. In fact, in my hometown, Butte, Montana, they used to smelt some of the sulfide off of the ore they used to put it on timber and light fires, and the company would come back about a week later after the fires were gone and extract some of the ore, and during that time created tremendous amount of air pollution, such that when you read, couldn't see at noon where you needed to go. And so all of these types of things predated both the Federal and the Clean Air Act of Montana. And the reason I bring that up here is that we as a state helped resolve a lot of those issues. And I think the issues that we're faced with today, I think the state is poised very well to also resolve any, if not all of the issues, that we may be faced. But we could not do it alone. And that's where I want to start with really what has worked well with the Federal Clean Air Act. And I've had the benefit of listening to the other forums, reading the material that the other states and locals and folks were here to present. And so that really helped me kind of see where Montana was situated with the rest of the states. And I'm very pleased that Montana is not very different. It has felt through the years in implementing this program that we have been very different in some of the interactions with our federal partners, and we're really not. And that's what I learned. As we talk about what has worked well, my sense is that this is where generally states point to the Federal Clean Air Act, that through the years the Federal Clean Air Act has worked well. The vast improvements in air quality, some of the flexibilities that were built into the Act, some of the programs that were developed to deal with some very significant problems. Non-attainment area issues are an example of that. It's helped the states, especially the state of Montana, kind of get our feet under us. We had the Clean Air Act of Montana before that, but we really, in the late 60s, early 70s, on into the 80s and 90s, we were very much neophytes in the area of air quality. So we really needed that assistance. And if I were to look at pre-1990 versus post-1990, I think you can almost see two very different attitudes and two very different ways of implementing that. Much of the effort prior to the early to mid-1990s, we were gathering that low-hanging fruit. And as we've heard talk about it, especially in the state of Montana, a lot of that fruit is gone. And so we need to be, we need to think of new ways of doing things, moving forward. The other thing that I think the Federal Clean Air Act recognizes is that generally local solutions are better. Cheaper, faster, better solutions, at the local level. So that leads me to, really what has not worked so well. And this is, in my experience, and I think in reading some of the things from the other states, this is where states are generally referring to the implementation of the Act and maybe the relationships that we have with some of the federal partners, or in some instances, the courts. And there are some things that maybe aren't working so well. Now, having said that, I don't know if the best solution is to legislate a relationship. I don't know. You know, as I started writing this, I think, boy, isn't it a shame we're to the point where I got to go and ask for an amendment to a Clean Air Act so that I can get my federal partner to talk to me. I think that's a very sad state. Happily, I don't think we're there in Montana and in Region 8, much to the credit of Jim Martin and the other staff in Region 8. We've seen a real turnaround in some of the efforts there. But what really hasn't worked well, and I'll get into some specific details, Mr. Chairman, is that EPA's involvement and their role really has hampered, you know, specifically the state of Montana. And I also will use the state implementation plan process. My difficulty in describing this, and I only put a couple pages together to address the questions that you asked. My difficulty in dealing with this is we hear the term SIP thrown about quite a bit. I will go back. I started in the permitting program as an engineer, and I was writing a permit for this facility that was covered by the SIP. So I went and asked the SIP folks what that meant. And so the SIP folks brought me into this room, and they showed me the SIP, voluminous, 10 to 20 feet of space on this cabinet. And so that is the difficulty, is that when we talk about SIPs, whether it's regional haze SIPs or infrastructure SIPs or maintenance SIPs or getting SIP approved for the New Source Review Program or something, not all SIPs are created equal. Not all SIPs have the same problems associated with them. And as I would hazard a guess that as we start to delve into some potential solutions, I'm not so sure that some of the more complicated, some of the more controversial SIPs have that very specific surgical solution.
How many SIPs would Montana have?
Well, Mr. Chairman, we have one SIP, but it consists of hundreds, if not thousands, of different parts. And when I say SIP, some of these are rules, some of them are demonstrations, some of them are analyses, some of them are EPA's programs that are taken and put into the SIP. Mr. Chairman. So that is a very difficult question, and I'm glad you asked that question, because that illustrates, you know, my point with the state of Montana. Montana has a lot of sources. I mentioned that. We have a lot of minor sources. Every year or so, we get a major source permitting action. So maybe the New Source Review Program isn't the most contentious program in the state of Montana. Since 2000, you know, there was a lot of energy development, a lot of interest in developing coal. We were writing permits for coal-fired power plants and doing that under the Prevention of Significant Deterioration Program, the PSD program. And yes, we had a lot of controversy, had a lot of lawsuits from environmental groups, had a lot of angst with our federal partners over how we issued those permits and what limits we put in there. I'm not so sure that that is going to be our problem or our issue for the next 10 or 20 years. And my comments more focus on the minor source SIP. And this is one that, as I engage other states in Region 8, and we just did it a couple weeks ago, there is a significant portion of Montana's SIP that is dedicated solely to minor sources. We have a minor source permitting program. We have other rules that are in place to develop some of those to regulate some of those sources that I mentioned in Montana. Sources that no longer exist. For some reason or another, they no longer exist. And that minor source program was placed into the SIP for EPA's approval, actually submitted to EPA for their approval and placed into the SIP in the early 1980s. And in 1980, our problem was getting our arms around all of the air pollution sources in the state. In 2012, that is not our issue. And our issue is dealing with volumes of oil and gas applications, that all of them are virtually identical. All of the control equipment, all of the emissions are virtually identical. There's just a lot of them. And so the example that I have of a process that really hasn't worked very well specifically is in our oil and gas registration program. What we really tried to do was look at that area of the SIP, and I want to go to page 32 of the minor source program that requires a case-by-case permit for literally 10,000 wells. And what I don't want to do is go through that case-by-case permit, but I don't want to sacrifice the environmental benefit I want to achieve the same thing through a different process. So what I want to do, and what we did, was we looked at all of the permits we had issued to date, looked at the control equipment that was required, and we took the most aggressive, the highest level of control, and we placed it in rule. And we said, okay, facilities, if you want the benefit of this administratively efficient process, you need to step up and you need to put controls on. Now, I don't believe the controls are going to change in the next 10 or 20 years. There's only so much you can do. But I don't want to go through the case-by-case, best available control technology analysis of weighing all the factors and issuing that. And so we put that in rule, and we submitted that to EPA, and this is the example I have of the difficulty, in that we submitted that in 2006, and initially it was not acted upon for a variety of reasons, and this is where I think the former EPA would try to maybe supplant states' judgment as to what they needed in their state. And when it was initially proposed, it was proposed for disapproval, and we couldn't figure out why, because the control equipment was really, the same. And it took a lot of energy engaging the regional administrator and our director to finally, just 2 weeks ago, we got a notice that it's going to be published in the Federal Register. So basically, our issues are changing some of the SIPs for new, creative, innovative ways. Are still held to, I'm not sure exactly what the standard is, what the demonstration is, but we have tremendous difficulty adapting our programs. We would like to modify our programs, free up resources to handle some of the more complicated things that are coming out with the new standards. We gave back our regional HAZE program because we had this backlog of state implementation plans, and our issues are dealing with minor sources. And really, the program we operate today really shouldn't be the same program that we operated in 1980. We really do have other facilities that we want to be very efficient and we want to regulate, but we don't necessarily want to do it through the same apply 60 days later, get your permit after a rigorous analysis. We've got the solutions that we can put in there. So that Mr. Chairman, has been very difficult. I will say, in doing this, we really we've engaged Region 8 EPA with the SIP improvement process. And we started that last fall, about a year ago. And we learned quite a bit. And, as a state, the first thing we did is say, what can we do better? And there's a lot of things that we can do better. And we were very pleased that the Region 8 staff, the technical staff and the management were very engaged in that process. This is not the same EPA, that we used to fight 8, 10, 15 years ago. It is very, very different. Having said that, I do know that the technical staff are having a difficulty. They are approving things that they can defend, not necessarily that they believe are right, because of some of the lawsuits, that are happening. So I think therein lies the challenge, and I think there might be an opportunity for various groups, various associations, to figure out where we have some agreement and where we can very precisely go in and affect some changes without virtually opening up everything, unnecessarily. So thank you, Mr. Chairman. I'm certainly available for any questions you may have.
Well, David, thanks very much. Our former chairman of the Energy and Commerce Committee, Joe Barton from Texas, came in, and Joe, we appreciate your being here. Our next participant is Jason, is it Howder, who's counsel with Aiken Gump, Strauss, Hauer, and Feld, and he's testifying on behalf of the Gila River Indian community. So, Jason, thank you.
Thank you, Mr. Chairman. The Lieutenant Governor, I'm standing in for the Lieutenant Governor of the Gila River Indian Community, and he asked that I pass on his thanks for putting on this forum, and thanks to the other members of the committee and the staff as well. The Gila River Indian Community, just to provide a little context of where we are and why we're here. It's a federally recognized Indian tribe that's located south of the Phoenix metropolitan area. It's right there in the south central Arizona area. 374,000 acres is the reservation size, and in 2011, the tribal implementation plan was approved by EPA, and I think it's the first comprehensive TIP approved air quality program that's a tribal specific program. So the community is a unique perspective in the sense that it is implementing its own plan to enforce the Clean Air Act on the reservation. It also is subject kind of through collateral, through EPA enforcement of the Clean Air Act in other areas within the state has been negatively or potentially could be negatively impacted by those enforcement actions. So it's, we kind of have a love, not, I wouldn't say hate, but we have some disagreements with the EPA, but we also are very cooperative in implementing our TIP. So I'm not going to go into, I echo a lot of the concerns that were raised here. I think for the most part, because the TIP process is relatively new, we don't have this long history with the EPA in terms of, I mean, our TIP took a long time, but we were really the first comprehensive plan to be approved by the EPA, so that's obviously going to take some time. But for the most part, the EPA has been very engaged in helping the Gila River Indian community set up its air program. We have a staff of 5 to cover Clean Air Act regulation on the reservation. Where our issues are, one is funding, and I think that's probably echoed by all state agencies that have to enforce federal law. The other is Ms. Rudolph referred to kind of the unique nature of the arid West, and the National Ambient Air Quality Standards issues we've had where I guess the traditional designations are really county boundaries. Well, in the state of Arizona, the counties are a size of some of these states. The size of, I think, Maricopa County, which is where the Phoenix metropolitan area is, the size of, I think, Connecticut. So, and the Gila River Indian community is part of that. So we're in this non-attainment designation, even though we are not the source. We're a rural community, and we're not the source of the pollution. So we've worked with the EPA in trying to redesignate to attainment. We've been successful with respect to ozone, but with particular matter, we haven't been as successful, and it's taken some time to really change that designation. The other issue I think that the RDEQ has is the permitting minor, non-major sources within the reservation, and EPA right now, I understand, is in the process of finalizing some new source review regulations that could assist us in doing that, but that is something that's lagging and is a source of concern for our enforcement of the Clean Air Act on the reservation. Now, with respect to where we have our latest relationship with the EPA in terms of Clean Air Act enforcement, really is connected to the regional haze rule in the northern Arizona area of the Navajo Generating Station, which is a large coal-fired power plant. It's quite a ways from our reservation. Why it impacts the community, the Gila River Indian community, is that a portion of the energy generated there goes to supply or to provide power to send water to from the Colorado River to the central Arizona area, which is a key part of the Gila River Indian community's water settlement. This water is a trust resource. It's held in trust by the federal government for the benefit of the community. Where we've become concerned is with the best available retrofit technology determination, the haze rule at NGS. The costs of that energy could go up to make our use of that water very unaffordable. And so it undermines this other federal piece of legislation, this water settlement, undermines that water settlement, and so you have the Clean Air Act in conflict potentially with another federal law. So we've been in consultation with the EPA, and under their new, what they call tribal consultation policy, and it's really unique to tribes where a government-to-government discussion occurs when EPA rulemaking or regulations may impact a tribe. And here we've undertaken that, and it started off somewhat rocky. I think EPA, my sense is when EPA is, it's used to being in somewhat of a litigation posture. It's either going to get sued by NGOs or is being sued by NGOs and could potentially face lawsuits once from industry as well. And so they've started off those conversations with a tribe in this unique situation in kind of this litigation posture, it seemed to us. And so what I mean by that is there didn't divulge a lot of information of, you know, where they were going in terms of the rulemaking, what we could expect, and what that meant to us in terms of the economic impact to Indian tribe. So, to echo Mr. Crancer's comment, with the BART determination, we were somewhat frustrated that this cost-benefit analysis really wasn't something that they were very keen on considering, especially when that seemed to be part of the rule, that they were supposed to consider some of the benefits of the BART determination compared with the cost it could be to not only the Gila River Indian community, but other tribes similarly situated in the state of Arizona, as well as the Navajo Nation, who uses this power plant to provide a lot of jobs. So it's a unique situation and something that I think the EPA wasn't necessarily prepared to deal with, but our consultation session our consultation process has improved. So, and I think from our perspective, those are kind of unique aspects of the Clean Air Act that state implementation doesn't face, and but I can speak to that also to answer any questions.
Well, Jason, thanks very much, and Syed, we'll recognize you, as Syed is the Executive Director of the Air Pollution Control Officer as well of the San Joaquin Valley Air Pollution Control District in California, and you're recognized.
Thank you, Mr. Chairman, members of the committee. Thank you for the invitation. We're happy to be here. It's a pleasure and honor to present some information to you, which we hope these forums will serve as the framework for ultimately leading to a constructive fine-tuning of the Clean Air Act legislatively, and also some remedies that could come about by some administrative amendments on the part of the EPA.
Forgive me for interrupting you just 1 minute. I want to just mention Gene Green, who's the member from Texas, has just joined us as well. And Gene, we're glad you're here.
Before I go on, let me just quickly give you a quick description of the region of the country and the state of California that I come from. San Joaquin Valley, or the Central Valley in California, the 8 counties that are 25,000 square miles in size, the size of some states, and the largest air district in the state of California. We are the breadbasket of the world when it comes to agricultural production, the largest ag production region in the nation. We also have quite a bit of oil production. Over 80% of the oil produced in the state of California is produced in the San Joaquin Valley. And over the years, we've done quite a bit to comply with the Clean Air Act, and air quality has improved quite a bit in San Joaquin Valley. We have reduced air pollution by over 80%. In San Joaquin Valley, we've reduced the number of violations, the number of exceedances, the magnitude of the concentrations of both ozone and particulate quite a bit. But as you can tell from my written response to your questions, we have some grave concerns with the current state of the Clean Air Act, and we are begging for some action by Congress to correct these deficiencies. Now, we are not here to suggest a total gutting of the Clean Air Act or any repeal of good provisions in the Clean Air Act. And in fact, we support a routine review of the standards that are based on science. We do support the goal of setting deadlines that force technology and urge expeditious action. But we think after 20 years since the last time Congress looked at the Clean Air Act back in 1990, quite a few lessons have been learned. And unfortunately, our experience shows that with the Congress acting essentially in vacuum at the time, not having the experience that we have now, many well-intentioned sections in the Act are leading to unintended consequences that are leading to a great deal of confusion and more rendering courts as policymakers rather than the Congress, which is what our democracy calls for Congress to make policies, not courts. Just to give you a few examples of, for instance, when the Congress was silent on including or considering cost effectiveness and technological feasibility in setting the standards, that made sense at the time, if one looks at that exercise as EPA simply establishing what is a health threshold for a particular pollutant. There are some people that support that regimen where EPA does not consider cost effectiveness and technological feasibility when they set the standards, saying that health-based standards should be strictly based on science. Unfortunately, that ignores the fact that the Clean Air Act, the way it's structured right now, does not really do that when EPA sets a standard. It is not simply and solely an establishment of an acceptable concentration that EPA publishes. It always comes with a prescribed, preset deadline also for meeting the standard and a number of milestones in terms of dates and reductions in emissions that have to be met. There are some that argue that you can take care of the cost effectiveness and technological feasibility issues in the implementation phase, but that's not doable if EPA, in setting that standard that comes with a preset deadline of 10 to 20 years, did not consider those factors. Let me give you an example. For instance, last year, EPA proposed a new ozone standard of 60 to 70 parts per 100 million that went to the White House, and White House at the time put a stop to it and said, we'll try it again in 2013. With that standard in San Joaquin Valley, in Southern California, and in other parts of the nation, to meet that standard, we basically have to ban fossil fuel combustion because it requires essentially zero emissions. The new standard in our area really encroaches on the background ozone concentrations in California. Now, there are some that are afraid in California that the federal, that the California's cap and trade program will ultimately lead into a ban on fossil fuel combustion, but that's going to happen only in 2050. In the case of Clean Air Act, with the new standard, we have to do that in 2032. As you know, 10, 20 years from now, as you can imagine, it's not possible to ban fossil fuel or hope for new technology that, that we can get to and have zero emissions from fossil fuel combustion and have it applied across the board. The other problem that we've identified is the fact that transition between the standards is extremely chaotic. The 5-year review that EPA has to do does not provide adequate time for all the information to be considered. And as Ms. Rudolph mentioned, it's also quite a few things that the states, and locals, and EPA have to do in those 5 years that are really not doable within the 5-year period. We suggest that the Act be changed to allow for a more orderly transition between the standard. When you establish a new standard, have the old standard essentially be subsumed by the new standard, so you have only one SIP in place that basically covers these various standards and the timelines that come with them. You asked earlier how many SIPs Montana has. In our region, we have 6 SIPs with hundreds of regulations, each dealing with the same pollutants. Of course, it's job security for attorneys and some groups like that, but it's a lot of confusion and a lot of chaos for agencies and for businesses that have to deal with these issues. I listed a number of other concerns in my written response to you. We believe requiring contingency measures in extreme non-attainment areas is irrational, and it's not really necessary. Extreme non-attainment areas already have thrown the kitchen sink in the plan. They have not left any measures for another day when we need them. To require to have those regions to have contingency measures does not make sense because there were no measures that were left off to the side. Section 185 penalties in the Clean Air Act are unfair and ineffective. These are the requirements that kick in if you fail to meet a standard. In San Joaquin Valley right now, the valley residents and businesses are subject to a fine of $30 million a year in penalties for not having met the 1-hour ozone standard, which, by the way, was revoked by EPA in 2005. And we believe, this is another one of those well-intentioned measures that were in the Act. At the time, Congress thought that if you impose that penalty, businesses will then clean up their emissions to make up, to reduce emissions in response to that penalty. In San Joaquin Valley, all of our businesses are already subject to best available control technology requirement, best available retrofit requirements, and really the only way to reduce their emissions once they are subject to that penalty is to either shut down or curtail their operations. There is really no other way that they can reduce their emissions. We have a number of other requirements in the Act that are impossible to meet. The requirement for severe and extreme ozone non-attainment areas to reduce the growth in motor vehicle emissions only through vehicle turnover measures. If that is, in fact, what the courts finally upheld, it will be impossible to meet. In San Joaquin Valley, for instance, it will require us to remove 5.1 million vehicles off the road. The problem with that is that we only have 2.6 million vehicles in the valley, so we're not going to be able to meet that. We believe that state and local governments should not be penalized when there are delays by EPA in action on their part. Unfortunately, right now, when EPA has a delay in what they have to do, there is really no recourse available to the state agencies and local agencies other than suing EPA, which is difficult to do. Now, I have to say that EPA, sometimes those delays are justified, and they have partly because of the confusions that exist in the Clean Air Act. So if we fix some of these uncertainties in the Clean Air Act, I think it will help EPA to also act more timely and not subject us to various delays that are problematic for us. We also believe the state and locals should not be penalized if failure to meet a particular milestone or timeline is due to sources under the authority of the federal government, or if the violation is due to transport of emissions from other regions, including other countries. We've talked quite a bit, in the economic terms about imports from China. We are finding in San Joaquin Valley and in the western states that there is a good amount of ozone, transboundary ozone, that is being transported to our region from Asia, in particular China. Studies by NOAA, federal government, show that in San Joaquin Valley, we could have about 15% of our ozone concentrations related to emissions from China. And right now, the penalty that I mentioned, the $30 million that we are paying, is because we are 1 parts per 100 million over the standard of 124, which is less than 1%. And if 15% of our pollution ozone is coming from China, I think we should not be penalized $30 million a year by not having met that. So we hope that Act could be amended to deal with that also. And finally, we recommend that in areas that have mature programs already, that we shift from a mass-based approach to meeting the standards to a more strategic approach of risk-based strategy. Not all pollutants are created equally. For instance, when you look at PM 2.5, it could be made up of ammonium nitrates, which are a respiratory irritant, all the way to diesel particulates, which are carcinogens and toxics. Right now, under the Clean Air Act, we treat all of those pollutants with the same level of severity and same demand on reductions in emissions. We believe in areas such as San Joaquin Valley, other areas that have already thrown the kitchen sink at regulating these pollutants, that we come up with a risk-based strategy that takes these other factors into account and basically puts a weight on different pollutants appropriate or commensurate to their impact on public health, and make public health really be the driver of what we have to do. So that's quickly a summary of the issues and concerns that we have. I'd be happy to answer any questions you have or further engage in dialogue in the future with you.
Well, thank you, Syed, very much. David?
Yeah, Mr. Chairman, before we get to Mr. Blanco, in his testimony, are we going to have a chance at the end of this to ask questions generically of everyone?
Sure.
Okay,
Yeah.
thank you.
We are prepared to stay all day. I guess maybe I'm not speaking for the participants, but you and I can stay all day. Arturo, you're recognized. Now, Arturo Blanco is the Pollution Control and Prevention Bureau Chief for the Houston Department of Health and Human Services. So I'm sure you and Gene Green are good buddies. And so, Arturo, you're recognized.
Thank you, Mr. Chairman, and the members of the subcommittee, and thank you for inviting the City of Houston to participate in this forum. And I'd like to greet Congressman Jean Green, and as well as Mr. Barton and Pete Olson. And by the way, I do live in Pearland, which is part of your district today. Yes. And I submitted my comments, written comments, and I will remark from those comments. And I have been given the honor to participate, being from the City of Houston in the Department of Health and Human Services, which is the city's, which is where we implement the city's air pollution abatement program within the jurisdiction of the city. Our program focuses in air quality monitoring, investigation of air complaints, violations of the state and federal Clean Air Acts. We take enforcement actions, and we participate in region-wide air quality planning, collecting and disseminating as well information to the general public on air pollution. So basically, I and my staff work on the streets of Houston, face-to-face with citizens, just about on a daily basis. So I'll just provide a brief perspective of the Houston environment, if you will, some of what we're doing, what we face in terms of challenges, and the need for furthering our efforts in air quality improvements. Houston is the fourth largest city in the nation. We are in the sixth largest statistical metropolitan area in the nation, involving 8 counties. Our area has a very diverse economy, energy, aeronautics, technology, and the world's largest medical center and one of the largest shipping ports, the Port of Houston. By virtue of our population growth and industry, we do face challenges implementing the Clean Air Act, underscoring that the Clean Air Act has worked in Houston. We have reduced air pollution, yet emissions from industry, including the many petrochemical refineries that we're known for, the emissions from cars, ships, trains, and heavy construction equipment. We are proud of our progress, and we have been proactively committing to reduce emissions in our Houston jurisdiction and working with our partners in the area. Houston is in non-attainment of the 1997 1-hour and 8-hour ground ozone, level ozone standards, and is classified as severe. Under the current SIP, we have in the region until 2019 to reach attainment. We are in attainment of the PM 2.5 standard and are closely following EPA's development on its proposed new PM 2.5 standard. As the Clean Air Act requires EPA to control over 180 hazardous air pollutants, some of these air toxics have been of particular concern to us. Air toxics trends in the Houston area have been improving, though, and yet they remain a concern because of their varying concentration in East Houston, which is the area by the Ship Channel, the Port of Houston, where freeways, highways, and rail converge, and near densely populated areas. Results show that air quality in Houston has been improving because of the implementation of the National Ambient Air Quality Standards, and although we are not there yet, levels of ozone are much less now than they used to be. We have collectively also done a great job in Houston in keeping us in attainment of the PM 2.5 standard, and the region has been placing more emphasis on monitoring and data results, which has led to better strategic controls to reduce emissions. And we face many challenges because of the frequent changes in the regulatory framework and the state's control over the city's air quality program. In Texas, the state is responsible for making the rules, issuing permits, enforcing the Clean Air Act, state and federal. We do monitor, though, air toxics within the city in thanks to our partners from EPA as well as a local foundation to equip us with the ability to do that. But our role is restrictive because of the lack of, because of our limitations in implementing effective pollution reduction approaches. With pass-through funds from EPA, and in partnership with the city maintains its air monitoring network, measuring the National Ambient Air Quality Standards. We must match those funds, and as some of the others have said, it adds to the financial burden of the city. We have been proactive facing our challenges, and we have done so, again, with limited regulatory authority. Texas empowers local governments to enter property to inspect the air and measure compliance with the state rules. However, in enforcing non-compliance, the city can only issue warnings, citations, or institute a civil suit to bring a regulated entity into compliance, and typically relies on its code of ordinance to respond to public health needs. The city's most effective means of ascertaining pollution has been by the use of a diverse inventory, I alluded to some of those already, of air quality instruments, quantifying detected air pollutants, performing comparative air and health risk analysis, helping give concrete meaning to quantified findings with the help of experts, reaching voluntary agreements with businesses to install better emissions controls and resulting in emissions reductions. Because of public health concerns and our limited ability to address them, concerns that we have raised in this regard include, and some of those have been improving, complex and long permitting processes, permits that are difficult to enforce, lack of air toxic standards to address public health impact, cumulative impacts in the current process that are not addressed, outdated emissions quantification methods by EPA resulting in underreported emissions, and we've done some work in that regard in partnership with EPA, and the state implementation plan process, which has been very confusing to follow. With all of the above said, again, air quality in Houston has improved, and we need to go further. National ambient air quality standards have been remarkably important for us in reducing air pollution. For specific improvements, it has already been said, sincere cooperation is the essence. So streaming implementation mechanisms, reducing bureaucracy can help in improving coordination within EPA and between EPA, states, and local governments. Congress may want to consider ways that incorporate multi-pollutant approaches that address commonly known precursors to ozone and particulate matter, as well as air toxics. And I know that efforts are underway by some of the states and locals working with EPA to improve the SIP process. And I've also read the recommendations in the Air Quality Management Report by the National Research Council in the first few years of the last decade, which I believe are still relevant to these forum interests. And that concludes my remarks for now, and I'll be happy to answer any questions.
Oh, well, thank you, Arturo. David, you want to ask some questions?
Yeah, Mr. Chairman, thank you. I guess I want to take a more of a contrarian view of what I've heard. Everyone seems to be offering certain suggestions of how we can improve on outdoor air quality. Some of the pitfalls with the states in the country. But I hear people say here in Congress that despite all the improvements we've made, we're still having premature deaths, low birth rate babies, asthma attacks have increased, and on and on and on with this. And statistically, they're probably correct that those things have occurred. So I wonder that given the statistics that we spend 90% of our time indoors, 60% of our time is in our own home. How do we differentiate our air quality issues in our homes versus in our work environment? Where are we getting sick? Where are these asthma attacks occurring? Where are these sicknesses and sick days occurring? Are they occurring at our workforce? And therein, where it goes, where you refer to as a structural change, is there a structural change necessary within EPA to expand their authority to go to our homes and our workplaces, our offices, where we spend 90% of our time? I'm curious what would happen in a state if we address where we spend 90% of our time. Is that where our people are getting sick? Or is it when they're outdoors? So I kind of throw that out to all of you, because I know we have 56 million children go every day to school classrooms where the air quality doesn't meet any standard. It fails. And when little Johnny gets sick, we blame it on the outdoor air quality. What would you do in your state if we expanded the EPA to include indoor air quality?
Can I touch on that? Look, I litigated cases for
Sorry, I had a hard time hearing.
I litigated cases for over 15 years, and causation is always the big bugaboo. And the other side of that equation is, you know what Churchill said about statistics. They're like the lamppost for the drunk, more for support than illumination. I think we have to be very careful in taking statistics of that nature and then making or jumping to a conclusion that ergo, we need more environmental ratcheting down. I don't think that case is made until that case is made. And for example, I talked earlier about the cost-benefit analyses that have to be run, the science-based approach to regs that should be in place. We had a big row about the health, so-called health benefits for some recent air regulations, the mercury rule, the utility max, so on and so forth. And there was some discussion then about double counting and so on and so forth. So I think we have to be very careful when a causation or linkage is being made. I think the objective evidence, I don't think anybody on this panel disagrees, that the objective evidence is that the air in this country over the last 10, 15, 20 years is dramatically better, and that we have the best air quality we've ever had in America. And it gets to the ratcheting down, the low-hanging fruit. You could put scientists in a room and figure out how to have zero emissions. Well, we would have to shut our country down and have no economic activity. So again, I think it's if EPA wanted to come into our homes?
Because the causation, again, goes back. I accept. Anyone that goes into Pittsburgh understands all you have to do is come through that tunnel and see the difference from 20, 30 years ago to where it is now. There's no question the air is better.
Yep.
And there is going to be a diminishing returns as we go lower in cost-benefit ratio. I understand it. But we've still spent 90% of our time indoors, and we're not addressing that, where the formaldehyde levels are, with the other ammonia discharges, with our gas discharges. What are we doing as a nation about that under the Clean Air Act?
Yeah,
Should we be addressing that?
I know
specifically.
I know a little bit about Pittsburgh, a little bit about Pennsylvania. I don't know as much about all these other
figured
states.
You had some
but
idea.
I do have a sense for, I think, what the public would say or react if we were to say to EPA, you as a Congress, let's increase your power so we can go, so you EPA can go into Tom, Dick, and Harry's and Jane's house and tell them how to do things in their house. I think that the public would react strongly, and I don't think that reaction would be a positive one.
Sayed?
Yeah, I was just going to say that the problem is a little bit more complicated, even if you strictly look at the outdoor air quality component of this. Right now, by law, our air monitors are located at the point of measuring worst-case concentrations on their own. So even when you talk about ambient outdoor concentrations, let's say for a particular county or a particular region, it is based on the worst-case monitor at the worst location that many people are not exposed to. So even when we talk strictly about the outdoor air quality, and we tell people in an entire region that you are exposed to so many violations or such a high concentration, even that is an overestimation of what the bulk of the population is exposed to. But I think, looking at the cause and for these various health impacts, it gets very complicated. I don't think there's any question, at least not on our part, that the science that EPA uses to establish the standards are adequate. Our problem is tying that to an unrealistic timeline and regimen to come into compliance that really causes the problem. I think if you could change the act to allow for an orderly, a reasonable timeline to get to that standard and do our best to ultimately get there to have zero premature deaths and things like that would work. But right now, when EPA sets a standard and then your progress is measured based on your worst-case air monitor at the worst-case location without really doing any cost cost-benefit analysis without doing any technological feasibility when they set that standard and then automatically apply a timeline, and realistic timeline that now will set us up for failure only, not for really progress for the public to see. That is the problem. I think, there's a lot of back and forth in terms of the question that you're raising, but I think the structural problem right now is that we do not set a reasonable timeline and a process to get to the ultimate standard. So, but I'm not here to question EPA's, standard setting and say, the cause and effects are totally unwarranted. It's just how you get there, and the process that EPA mandates is really the problem.
Is the San Joaquin Valley area in non-compliance right now on ambient air quality?
Right. We have made significant improvements, but right now San Joaquin and Los Angeles are the two worst regions, with Houston once in a while popping in terms of having the most number of violations. But there has been significant progress. We do have programs right now, for instance, that we send hourly notifications to school children, parents, and faculty to keep your children indoor today for this particular hour. Don't send them outside.
Well, in 2013, we anticipate EPA is going to make some changes on ambient air quality standards, and I'm assuming there will be a larger percentage of the country in non-compliance, and certainly San Joaquin and Los Angeles would still be in non-compliance, I'm assuming.
Right. In a way, we're sort of rooting for that, because there's the only silver lining in that is that it will no longer be just San Joaquin, Houston, and Los Angeles problem. We may have more allies and bring in more
But
help.
what are the practical effects of being in non-compliance? You talked about $30 million a year fines. I mean, that hasn't been enforced, or has it?
Yes, it is being enforced right now. In fact, for 2 years, we have been collecting about $30 million from businesses as well as residents in the form of DMV tax that they've had to pay. EPA gave us an option: fine yourself and keep the money and spend it on air quality, or we will fine you and send the money to Washington. When we took the
So
other.
you can either do it or they will do it, except the money will go in a different place.
Right. The only option we had is to impose our own local fines and collect the fines
But there must
locally.
be some reason why this area is in non-compliance that is outside your control.
You're absolutely right. We have some God-given conditions that we have no control over. The valley is a bowl with a lid on top of it most of the time. During summer and winter, we've reduced our air pollution almost to 10% of what it used to be 20 years ago, but we still have a lot of high concentrations because of geography, topography, meteorology, air pollution from China that we have no control, air pollution from our neighboring Bay Area, San Francisco counties that come to the valley. And in the current frame of the Cleaner Act, there is really no way to be compensated or be given some deference for pollution sources that we have no control over. So when EPA sets a standard, they don't take into account, look at the meteorological conditions in San Joaquin Valley and see how long it takes to ban fossil fuel to really get to that standard.
Well, I don't want to monopolize this, but if all of you've talked a little bit about this cooperation between states and federal government and flexibility and so forth, and if states had more flexibility in their SIPs, it seems like you could work through these problems a little bit easier. Maybe I'm naive about it, but do any of you have any?
Mr. Chairman, there's one other impact of being in non-attainment, really, and non-compliance, and that is it puts a limit and an impairment to any economic, any expansion, any plants putting on a new shift, any new plants coming in. So we have the perverse situation where the air is getting a whole lot cleaner, but we're not growing anymore economically, which, I'll leave it to the policymakers sitting here in Congress, but if you're talking about the Chinese that we have to compete with, if you're talking about the Indians that we have to compete with, if you're talking about the rest of the world we have to compete with, that doesn't set a very optimistic competition table for us to compete with the rest of the world. And I, like a lot of folks in here, I have teenagers. Those teenagers are going to go to college, graduate, whatever they want to do. Maybe they won't go to college. Maybe they'll go to trade school. They're going to have to compete with their counterparts in other parts of the world, and we're going to have to solve that competitive puzzle, or my kids are not going to be as well off as I was and I'm sitting here better off than my parents were. So this may be the first generation in history in which we can, if we can take a, I don't want to do a show of hands, but you think about it and you go to your cocktail party circuit at home and you do this. How many of you think you're better off than your parents? You'll see in a room almost everybody's hand go up. But then if you ask the next question, how many of you have concerns today that your kids aren't going to be better off as you or as well off as you, you will be amazed at how many hands go up in that room.
Ed, again, I heard one or two answers back to my challenge. And it goes back, what I heard from Mr. Crancer was a very good political answer. It would not be popular in Mildred Schmidt's home in Fallensby. I want to deal with science. I want an acknowledgement or a recognition from the states. Do you think, from your own responsibilities with your own entities, whether or not you agree that indoor air quality can be just as much a detriment to people's health as outdoor air? And we're ignoring, I believe, under the Clean Air Act, there's no accountability for indoor air quality.
I'd like to
So
comment.
I'm just curious, where's the problem? Where's the causation? Because we're going after one group. We're going, and in my area from West Virginia, we're going after our coal industry. And I don't know whether that we should be broadening out to look at everything and not picking winners and losers. So I'm trying to understand whether in your individual state you concur that indoor air quality can be a detriment to people's health.
I'm not sure that I'm going to answer your question, but I'll add is that, commonly, as I mentioned, that we work day to day with citizens in the city of Houston because of their concerns about the environment, and the environment that they see is both indoors and outdoors. And when we respond to those, frequently I work with my counterparts who are expert in indoor air quality. So we have to work with each other. Again, I mentioned several times that we work under very limited regulatory authority, and that's exactly one challenge in that area there. The other side of it is when it comes to minor sources, and Mr. Clem mentioned them, is an important challenge for us in the city of Houston as well. And we frequently find that when we are trying to address air pollution issues, we come across standards set by OSHA, for example, which are not necessarily enforceable standards under the Clean Air Act or by EPA. And to what extent EPA works with that area, I'm not really sure, but it does open the question that there are many opportunities to bring in more heads together to see how we can address the common effect down on the ground by the citizen who is calling us and says, we have a problem, indoor, outdoor, and we try to troubleshoot that. So,
Mr. Chairman.
Robert, you had a
Go ahead, Congressman Watson.
Okay,
No.
I want to thank you, Mr. Chairman, for doing this and making it bipartisan with Mr. Green here. I want to thank all of our panelists and members who took the time to come. I think Congressman McKinley's is just telling the truth that indoor air pollution is a significant cause of health problems. Having said that, the answer, in my opinion, is not to give the federal government control over indoor air pollution. We've got enough problems with the federals and what they're trying to do, in ambient air quality outside. There'd be a riot in my district if we gave the EPA the right to come into somebody's home next to me and tell them they couldn't smoke or they couldn't, whatever it is that they're doing in there. That's not a good idea. It's probably not a good idea at the state level either. Yeah. And my friend here from the city of Houston, I'm not sure the City Council of Houston would want to try to tell people what to do inside their homes. So you might set some sort of generic standards, kind of a base case system just for, for information purposes, but I just can't see that. My question to the panelists would be, everybody's kind of danced around this cost-benefit issue. Federal regulation has, and y'all have been very benign in your way you've tended to compliment the EPA. I'm not that complimentary to the EPA in the way they do things. But you can't just keep on the ozone standard, if .08 is good, then .07 is better, and then .06 is even better than .07. There is a law of diminishing returns, and our friend here from the San Joaquin Valley has told us that. You know, if God made it, the topography a certain way, EPA is not going to make it possible to meet that arbitrary standard. Do you believe that there is a consensus to put a cost-benefit test into the Clean Air Act? And I'd even like to hear what Mr. Green has to say about that question, you know, because that's probably the one thing we could do that would make the EPA be a little bit more responsible to the real-world problems that you folks at the state and local level have to deal with.
And before you all answer that, I know you did have a question too, right, Gene?
And thank you, and thank you, Joe, for bringing this up. One of my questions is not only of all of them, but obviously I represent East Harris County and part of the city of Houston, and am concerned because over the last year, we have had announced so much in plant expansions because of our reasonable price natural gas and the primary chemical facilities, or even some of our refiners. Although having the industrial base I have, there is not a day goes by that we don't have some permit with either TECQ, our state environmental agency, or our EPA, ultimately, that in the city of Houston only has certain small part of that in our area. I know my Lyondale refinery and some chemical plants there in east side Houston. And I want to compliment, though, because we probably have the most monitored air, and because the city monitors, the state monitors, the EPA, and a number of our industries have been doing for the last number of years at the encouragement fence line monitoring, because they don't want to be blamed for someone else doing something. And Mr. Blanco, and I'll give you one plant as an example. There was a chemical plant that was shut down on 225 in the city of Houston. It was mothballed years ago, and I watched it being rebuilt, literally thousands of jobs, and they discovered that they could, propylene is something we need in the industry. And because success in South Texas, a lot of propane, so they're turning propane into propylene, and I met with them. It's a relatively new plant, I assume matched the city of Houston requirements, and now they want to double their capacity because there's so many customers. And their issue wasn't with the city, the state, or even EPA, except that the state of Texas is not issuing carbon permits. And I was going to ask you that is the current law hindering some of our industries expanding? Because in that case, I know it didn't, because they took a mothball plant and rebuilt it, and I assume to the latest standards that we have. Are you familiar with that particular plant? Because I was impressed with it when I was there and the success they're having.
Petrologistics, right? Yes, we have worked with them. Obviously, the state is the regulatory authority that issues their permits, but they have touched base with us to ensure that they are not raising any concerns. So we have sent our engineers and observed their power up of their processes. I think last year, I believe, or earlier this year, can't remember. But yes, we have worked. I'm aware of that of them in that sense. We have had a couple of meetings, and I believe they're doing a good job in informing us in terms of their step-by-step process.
Okay. So. Is there any regulatory delay? And I know it's not necessarily going through the city, but you're aware of it going through the state agency on their process and when they reopen that plant?
I can't tell you specifically. I would have to get back with you on that. I know that they were working avidly to get up and running, and they had some challenges. I think some of those challenges were process challenges. They were renewing some of their equipment. I can't tell you specifically what challenges they're having with the regulatory process in terms of their permits.
Well, and like I said, when I met with them in because EPA is requiring carbon permits, and in Texas is the only state that decided not to do them. EPA doesn't typically issue permits. They give their law rules to the states, and the states does. But in our case, we're having to get EPA, our regional office, to issue these permits, and they're having to reinvent the wheel because most of us would rather EPA not have to give those permits. We would rather continue that cooperation with the state, and that was their issue. And I think there are a couple other plants that are at the same level. They want to expand, but now they have to get these carbon permits, but nobody, the state's not issuing them. I think other states are.
Right. We are working closely with the state when it comes to reviewing the permit to provide input to the state and then finally issue them. But in that sense, we're not working with EPA as they're reviewing for greenhouse gas permits.
Congressman, real quick, on the carbon permit situation, let me comment on a couple of things. First of all, that's another example of the courts setting policy in the U.S. versus Massachusetts case, and then EPA running with that ball, and then EPA doing something that arguably the Congress said no to, and that is issuing carbon permits of any nature or to begin with. The other question about the cost-benefit analyses that the Congressman Mr. Barton asked is that be careful in that there already are cost-benefit analyses that are required. Take, for example, the one, or done, take the one in the Utility Act, for example. That was one that was roundly criticized for being fanciful, actually, and including double counting and so on and so forth. So it gets back to Churchill has, he's great on everything, that, and his quote about statistics is applicable here. So it's, again, a tool, but it has to be used and not abused. Cost-benefit analyses are useful tools, but can be cooked.
Yeah. Robert and then Syed.
I'll try to go back and answer a couple of questions, starting back with Congressman McKinley on the indoor air and stuff. I mean, there are, and someone alluded to, in the workplace, OSHA standards, which Department of Labor, OSHA, and at the state level, OSHAs have what are called permissible exposure limits that do set exposure limits for 8-hour exposures and stuff. So to a certain extent, some of the indoor air issues are being addressed. We have asbestos NESHAPs. The challenge with the more residential and personal living situations is you really get into consumer products that may be in the home, or smoking and things like that, where you would then be regulating personal behaviors. But that is a real challenge. But obviously, your indoor air comes initially from your outdoor ambient air, so to the extent it's already contaminated when it comes into the home, you're going to have a problem. So it's the question of, and you're right, there are things that do cause potential health issues from indoor air exposures. Lead paint, and lead was obviously an issue not only from air, but just the lead in the paint and getting in ingestion. Wood stoves, things like that can cause indoor as well as outdoor issues. But you really are getting into a difficult area of regulating that. There have been some things for like children's diesel bus retrofits where school children are not riding on diesel buses and getting exposed to diesel fumes and things that the Clean Air Act and communities have made significant efforts to try to improve. So there are some things I think would be very difficult to start regulating sort of consumer product behavior, certainly within the confines of the Clean Air Act. On the expansion and the cost benefit, I think to your more generic question on expansion of businesses, there are challenges. I allude to one, the New Source review, the uncertainty of if a company is looking to expand by retooling its facility. I mean, it's pretty straightforward and easy. If you have a whole new process line or a greenfield site, what you have to do, and you go through a best available control technology, and you can have debates about what's reasonable controls for that particular facility, but that's a little more straightforward. It's when plants are trying to retool existing equipment and upgrade, and is that a modification or is it routine maintenance, and should they put on those controls? The other issue and challenge you have for existing facilities or a new facility for that matter in non-attainment areas, if the area is not already meeting the standard, the Act has this sort of ability to allow some new jobs and growth, but you have to get those offsets and you have to put on more stringent control technology. So it's a capital investment decision. They may have to spend more for controls, and if you're going to increase your emissions by 200 tons, you're going to have to find 220 or depending on how far out of compliance you are, maybe 240 tons of other reductions to come off the table. So those are some of the challenges in terms of expanding businesses in areas that are not meeting the air quality standards.
We have Syed, then Mr. Olson, and then Gene.
Just quickly about indoor air quality, but then I want to talk about your question about cooperation, which I think ties to this whole cost effectiveness analysis. Indoor air quality, first of all, we don't want EPA to be in charge of that, but I don't think when it comes to air quality, indoor air quality is really a problem. At least the science does not indicate that. We did some studies in our region where we actually put individualized monitors on people's, some cohorts that participated in the study to actually measure ozone and particulate everywhere they went. And air quality at their office space, at their homes was a lot cleaner. I think a bigger issue is when you tie certain results to particulate matter or ozone, those questions, those issues have to be questioned sometimes. For instance, in California and the coastal areas where the air quality is very clean, we have asthma rates going up tremendously. And people talk about air pollution causing asthma or other air pollution. Some of those studies need to be questioned. It could be your diet. It could be a few other factors that are involved. But I don't think indoor air quality in relation to outdoor air quality is significant, at least not the studies that we've seen. But in terms of your question relating to cooperation, I think it really goes to put in cost effectiveness in the mix, without which EPA's hands are really tied to really cooperate fully with us. I don't think EPA is really the problem. They're a federal agency, bureaucracy. Given that standard, certain one-size-fits-all approach and some inefficiencies we're willing to live with. But I think at the end of the day, it's really the fact that Congress is silent, has not expressed its will on how cost analysis should be considered. Now, people that support the current regimen, they pass on a certain misinformation. I think that if you don't pay attention, you may fall for that. They say EPA is only establishing a health standard to maintain public trust in your health standard. Let's not put cost effectiveness in it. The fact of the matter is that under the Act, that's not what EPA is doing when they set the standard. When they set a standard, it automatically comes with deadlines. 3 years after the standard is in place, you have to reduce your emissions by X percentage every 3 years. Within 10 to 20 years, you have to come into compliance. A whole host of milestones kick in, all of which have not taken into account cost, economic feasibility, or technological feasibility. And when you have those constraints that EPA did not consider, no amount of goodwill on the part of EPA would make up for that, for them to be able to do what you need. In our region, we have great relationship with Region 9, with the headquarters. They fully understand our problems. They try to be creative. But at the end of the day, Congress has tied their hands because you're silent on whether cost analysis can be considered, whether technological feasibility can be addressed, and if those are not part of the mix, if you don't separate setting the health standard from the implementation deadlines, at the end of the day, you're tying EPA's hand, and there's no way for us to cooperate fully. It's not their lack of intent. It's just they're not able to.
Mr. Chairman, I'm just a little surprised. Did I hear you say that you think indoor air quality is better than outdoor air quality?
For the most part, in terms of ozone and particulate. Now, you could have, depending on what state you live in.
Okay, well, California wrote a report. We have a copy of it in our office. It says that the indoor air quality is probably 50 times worse than outdoor air quality. And I know the EPA on its own website says the indoor air quality is 96 times, perhaps 100 times worse than outdoor air quality. So I'm a little surprised by your remarks with that, because not only your own state says it's worse indoors, but the federal government also says it's worse indoors.
Okay, Pete.
Well, thank you, Mr. Chairman. To keep the Texas trilogy going with Congressman Barton and Congressman Green over here, welcome to all the panelists. Mr. Chairman, thank you for putting this together. Special welcome to you. Michael, good to see you again on a panel. And Arturo, great to see you. As one of my bosses back home from Texas, I really appreciate you coming up here. You know, it's football season in Texas. And so you also realize that a little over 24 hours from now, Dawson High School in Pearland will be playing in Reliance Stadium to advance to possibly go further in state playoffs. They're ranked #1 right now in 4A. And you also realize, and no offense to you, Mr. Martineau, but 24 hours after that, the Houston Texans, with the best record in the NFL, are going to be traveling to Tennessee to take on the Tennessee Titans. And I appreciate your sacrifice coming up here, taking a chance that you might not be home for the Dawson football game or to watch the Texans beat the Titans there in Nashville.
You forget the Dynamo.
Oh, the Dynamo, true. Yeah, the soccer team's playing for the world, not the MLS. Yep. Yeah, beat DC United last week there in Houston.
I hope you're not biased against soccer.
We could. Now, we can talk about soccer, a different thing. Mike, one thing, too, I didn't realize you had a relationship with my colleague, Mr. Griffiths, so I'd get offline with you, tell some stories. I'd love to have those.
It'll take a few hours. We'll have to do it later.
Good deal. But putting aside my football helmet, which is pretty hard to do for a Texan, I'd like to talk briefly about the issue at hand, how I develop cooperative federalism with EPA. I'm coming at this as a member of Congress from EPA Region 6, which unfortunately our EPA, it's pleasant to be here because I hear some regions EPA is cooperative with you. In our region, they've been an adversary. And one example that you mentioned it, Michael, is the flexible permitting process. That's a process, a SIP that our state put together over 15 years ago to limit our air emissions. They did it as an amendment to the SIP. It had been effective for President Clinton's administration, President George W. Bush's administration, the first years of President Obama's administration, and the EPA rolled in there and said, no, we can't approve this thing. You guys, we didn't approve it 16 years ago. And so they got rid of all the permits. Some of these guys had to go through, 42, they had to deflex, is what they called it, but 42 power plants and refineries had to go through again and refile their permits and go through the process one more time. The other ones are waiting. The court, the Fifth Circuit, finally said this was terrible and said remanded it back, but they haven't told EPA what to do. And so I'm very concerned about that going forward. I mean, the real problem I have with not only EPA's actions, as we said here, our air is cleaner. I moved to Texas in 1972, Houston. We were booming. I lived right by the Johnson Space Center, about 20 miles from downtown. You could see downtown maybe 10 days of the year through the haze. Now, 10 days of the year, you can't see it. It's clearly visible. Our air has gotten demonstrably clean. We doubled the national average in reduction of some of the emissions that EPA regulates, doubled the national average, while we're the fastest growing state in the country. Growth doesn't go with cleaner air. Yet we did in Texas. And EPA said that's not good enough. And so my question, it's very frustrating, is if we could do one thing for your states here with the Clean Air Act, what would it be? I mean, first you, Mr. Sondra. In California, you got very similar problems with us with all the ozone. Well, it's non-attainment areas. I mean, as you mentioned, our industry is based on everything they can to reduce emissions with all the technology they've got now. If we have to go further, guess what? That's mean transportation. People are going to be restricted driving. In Texas, man, if you can't drive through a Whataburger in your pickup truck, woo, boy, there'll be some problems.
If I were to ask for one thing, and if you don't do this, next year EPA is going to come up with a standard which will require all of us to basically ban fossil fuel combustion in California at least, and in many other regions, and that is to separate the standard setting and the implementation mandates and timelines. Right now, EPA cannot consider, as we've talked about already, economic feasibility and technological feasibility when they set those standards. And when they set those standards, it automatically comes with deadlines to meet. I would ask that you separate those two. EPA can still only consider science when they set the standard, but separate that act from the actual deadlines and mandates that come with that. And for those deadlines and mandates, in terms of when you have to meet those standards, have Congress require EPA to consider economic and technological feasibility along with environmental conditions that we talked about, for instance, in the valley with a bowl with a lid on top of it, to take that into account. What is the most expeditious timeline you can get to meet the standard that is economically and technologically feasible. That would be the one thing that I would ask.
Thank you, Mr. Klemp. From Montana's perspective. I'm sorry.
Gee, just 1 minute. I want all of them to respond to your question, but Gene's getting ready to go, and you want to make one comment.
Well, I appreciate the cost-benefit analysis issue that my colleague from Texas brought up, but we do have that already. And I know there's some discussion about EPA doing that before they do it, but EPA, we task them with our environmental requirements. But we have the Office of Management and Budget, and I know Congressman Barton and I have, particularly with cross-state pollution issues, have met with the Office of Management and Budget who look at that before any of those federal rules go into effect. We don't always get told yes, but I don't get told yes by the EPA all the time either. But we have that built in our system of regulation because someone needs to look at it because we're looking at shutting down 5 refineries that I represent in our district. You know, that's a huge economic impact, not only on my area, but for the country. So I like to have somebody we can go to do that, and EPA can do their environmental, but we need somebody looking at, can we really afford it?
Yeah, Representative, you don't have to talk to me for sure about what closed refineries mean. A year ago today, we were looking at 3 closed refineries in southeastern Pennsylvania. We've revived 2 of them with increased vigor, and another one will be repurposed to integrate with the shale gas opportunity in Pennsylvania. And by the way, those refineries, the one in Sunoco, which is now Philadelphia Energy Solution, is going to use Bakken crude oil from North Dakota, which is lower sulfur, cleaner, and is extracted by, guess what? Hydraulic fracturing, horizontal drilling from a shale formation, which sounds familiar probably to a lot of the states here.
Mr. Chairman, I know on a yearly basis we do an offshore rig tour, and I appreciate it. I enjoy it, but I think sometime maybe we ought to try our energy subcommittee to go visit a refinery, whether it's in Pennsylvania. I welcome you to in our district, but we're a little further away than Philadelphia.
Yeah.
But in the success of keeping those refineries open, because the shale gas actually makes it cheaper to refine oil, and so that's a benefit. So.
Yeah. Thank you. I might just make one comment on this cost benefit, which I always get a little bit confused about, but under ambient air quality, EPA does not have to consider cost in setting the standard, but they consider the cost in the implementation of it. So the question is for Mr. Olson, if you could do one thing to the Clean Air Act to help you do your job better.
And Mr. Klemp, you're up with Montana's perspective, sir.
Thank you, Mr. Chairman. Mr. Olson, thank you very much for the question. In briefing my director, Richard Opper, coming down here, he asked me, you know, Dave, what's the one thing that you would ask for when you go to Washington, D.C.? So I'm very well prepared for that. And I tried to get into that into my initial overview of this. And I'm going to go back to SIPs, state implementation plans, and I'm going to separate them into 2 broad categories, mandatory SIPs versus discretionary SIPs. What I talked about with the minor source program or minor source SIP issue in Montana, that's very much a discretionary program, in that while we are required to have some sort of plan to address air pollution, it really wasn't defined what we put in it. So in 1980, we put everything that we had in it, and we're forever stuck with what we did in 1980, and things are different in our state today. And so for those discretionary SIPs, I would ask that let's not start with the most difficult, the most complex, the most controversial issues. Let's start with some of the very simple ones where there is a greater likelihood of consensus. And if we could define the regulatory box that the state of Montana needs to live within and will gain all of its flexibility from in moving forward with some of our discretionary SIPs, maintaining those SIPs, changing those SIPs, not compromising protection but maximizing efficiencies. That's what I would ask for, is more definition on a regulatory box from a discretionary SIP perspective.
Yeah, define the battlefield and let you guys decide how you want to fight the battle. How about the Gila Indian Reservation, Mr. Howder?
Aside from more funding, probably our program relies on a lot of federal funding to hire the staff. I think more flexibility with respect to, understanding with the National Ambient Air Quality Standards, our region we don't have control over a lot of the sources that be causing some of the problems there. And not just for the community, but the arid West in general. I think Ms. Rudolph alluded to, you have forest fires, you have all these other different conditions. So looking at it more on a case-by-case basis, and also with respect to the regional haze rule that we're dealing with in northern Arizona, our concern really is the control technology may not solve the problem. So having all this effort and time and money go into negotiating and working with the EPA about finding a pragmatic solution, if at the end of the day whatever's required doesn't really address the haze problem in northern Arizona because of the region, just because it's the arid West and it's different than coastal areas or the Southeast. I think at the end of the day, some flexibility in dealing with the different regions in case-by-case scenarios.
Michael, from Pennsylvania's perspective.
It's a great question. The problem is you can't legislate attitude. You can't legislate relationship building. You can't legislate respect for the law. You can't legislate, maybe you can actually, I'll put it to you, maybe you can legislate a hands-off of the Environmental Protection Agency using environmental and/or air policy to set national energy policy, and using environmental law to be the driver and really the sole driver in many cases of our national energy policy. So maybe passing a National Energy Act which establishes our national energy policy and takes EPA out of the business of, and it seems to be their big business right now, of establishing a energy policy. And I'd also say legislate a prohibition on picking winners and losers.
Yes, sir. Mr. Martineau, from Tennessee's perspective.
It's a very good question.
Oh, I'm sorry.
Martha.
Yeah, I'm sorry, Ms. Rudolph, I skipped right past you.
That's okay, I've
Colorado's
been a little
perspective.
quiet.
I was getting an earful with the Corey Gardner over here, so I feel like no Colorado's perspective. I'd love to hear it from you, ma'am.
Thank you. Thank you for the opportunity to answer the question. I think that the Clean Air Act actually has the tools in place that would allow EPA to do what I think is important, which is what I think you've heard, which is look at collaboration and being more responsive to what states need, the unique issues that are in each of the states and each of the areas, and giving states the flexibility to come up with their own programs. EPA actually, I think, exhibited this fairly recently when it adopted the New Source Performance Standards for oil and gas. It did a robust job of asking for information from the regulated community, seeking advice, looking at states, actually modeled the NSPS regs after what both Colorado and Wyoming did. And I think consequently, it ended up with a regulation that received a pretty widespread support from the industry and from the states. And I think that's what EPA really has to do. It can't, in a vacuum, look at how do we, here's the regulation that we're adopting, and let's just put it on the table and see what happens. It needs to have guidance documents when it adopts the regulations so that it really thinks about how the regulation could be implemented, and it needs to initially just work with the states and with local governments and with the tribes and with the regulated community and with environmental groups to try to come up with a package that really meets the goals that are established and yet in a reasonable and responsible and cost-effective way.
Thank you, ma'am. Now, Mr. Martineau, from Tennessee's perspective, the volunteer state where my sister lives, by the way.
Oh, thank you. It's a good question, and I think I would answer along the lines of the flexibility and the ability to adjust to local circumstances, and that ends up taking the place. Martha talked about the exceptional events burden being very high to demonstrate it. And admittedly, some of the barriers to flexibility are built right into the statute, as Mr. Sededrin said. In theory, we have flexibility built in time and implementation once you set the NACs based on science. But the statute has some deadlines that you only, if you're a marginal area, you get so many years without regard to actually the cost for a particular area. The example I used, the NOx substitution, VOCs reductions didn't make sense for us for ozone, but we were driven to that regardless of the fact that NOx would be a better substitution for that. So the flexibility and lowering the sort of burden to sometimes prove a negative to get that flexibility adapted at the state level and not requiring sort of the uniform approach across the state. I mean, EPA's job should be to set those broad national standards, whether the health-based standards or the new source performance standards, and let states figure out the best way to get there without having such a high threshold to get outside their desired approach to get there.
Again, like was said earlier, here's the target you guys need to hit. You figure out how you hit that target. Thank you. Last but certainly not least, the man from Pearland, Texas, one of my bosses, Mr. Blanco.
But I'm here on behalf of the City of Houston. Well, in my remarks, I mentioned growth, I mentioned public health, I mentioned, alluded to quality of life. All are extremely important. I don't think anybody denies that. And it has already been said, relationships cannot be regulated. So dialogue needs to be had. So more dialogue, results-oriented cooperation between the agencies at the federal level, state and local levels is where I would start.
Thank you, Mr. Chairman. I yield back the balance of my time.
Pete, thank you. And, Mr. Sayed.
I just wanted to, you mentioned that in the Act you can already take into account cost-benefit analysis when it comes to implementation. I just wanted to urge caution and fallen for that because that's really not the case. When EPA sets a standard, it comes with deadlines. For instance, the next standard for ozone requires fossil fuel ban by 2032. There is no way you can exercise flexibility within that timeline, within the next 20 years. How do you ban fossil fuel combustion? So even though that's what EPA uses as defense, that we will deal with that in the implementation phase, they really cannot because the standard comes with specific deadlines that were devoid of any economic analysis. So I just want to make sure there's some caution and fallen for that cost-benefit analysis could be taken care of in the implementation phase.
I want to add on to what my friend Bob Martineau from Tennessee said earlier about the, when you're in non-attainment, the difficulty for expanding, for putting in a new shift, putting in a new factory. And you did accurately say that what you do is you just put in a new investment. But as in economics and in investment, it's all at the margin. And we're competing on a world stage for that marginal additional investment. So it's not as easy as saying, well, just spend that additional investment when you've got folks competing, even sometimes in their own companies, for capital to be directed here, to be directed there, oftentimes overseas if the investment is too burdensome here. So that's an important thing to keep in mind, is that when we're talking about increasing our manufacturing base, increasing our petrochemical base like we are doing right now in Pennsylvania, because of our cheap energy, because of our clean energy, et cetera, et cetera. And I include coal, by the way, in that clean energy because we burn coal cleanly in Pennsylvania. We have to be mindful that it's a world stage for capital. And states sometimes see that it's a national stage. An investment that is looking into my state, if the investment climate or the regulatory climate is too hostile, which it isn't, by the way, might go to another state. So we have to be mindful for that. And again, I mean, our kids' future is at stake here. It's not just as easy to say, well, don't worry about it. They'll just add more money and they'll build that plant. That often may not be the case. And they'll build that plant in China or in India instead of building it in Tennessee or in Pennsylvania.
Well, thanks very much, Michael. And I want to thank all of you for, I know it took a lot of preparation. I know you travel long distances, took a lot of your time, and we genuinely appreciate your coming and giving us your views and your experiences. And in closing, I just want to ask just a couple of other questions. One, many of you have talked about the SIP approval process. So my question to each one of you would be, do you think there needs to be some additional guidelines on limits of time for SIP approval processes? And then second question, there's been some discussion about litigation and working with the states on settlements with third parties. How many of you would do view that as an issue, or is it not an issue? So if each one of you just briefly comment on those 2 points.
Mr. Chairman, under litigation, I would suggest that if we could add a provision that that makes agencies entitled to legal fee recovery in cases where we win the lawsuits. That might help with respect to litigation, or over litigation that we get from some of the groups. As far as SIP approval, there are times where, for good reasons, legitimate reasons, EPA has to delay action on some actions, on some decisions. But sometimes the time takes too long. We had one example when we sent an EPA an ozone plan for the 1 hour plan in 2004. They did not act on it till 2010. And then in 2010, when they approved it, litigants took that to the court saying, well, it was too late. The information has changed. Emissions inventory has changed. New information is available, which is, of course, true after, failing to act for that many years. And then when that happens, there is no recourse for businesses that have already gone down a path of complying with a plan that now has been disapproved, and then the work that comes about. So my suggestion would be that provide some mechanism that puts a deadline on EPA to act, and failure to act would be an automatic approval of the material that has been sent to them, and unless there's a mutual extension for good reasons between the 2 parties agreed upon, a failure to act within a year or 2 or whatever timeline should be deemed automatic approval.
Mr. Clem.
Thank you, Mr. Chairman. I don't have too much to add. I think defining the regulatory box or the decision making and allowing states to use their judgment, certainly. I think that the timelines are there. It's 18 months, roughly, and automatic approval would certainly help. And yes, we suffer from the settle and sue type, or sue and settle, excuse me. We have SIPs that are 15 to 20 years old that are part of consent decrees, and we've asked to be a part of, but really have not been allowed. And I really don't want to sue my federal partners. I don't have those resources available, and the resources I have, I would rather not use them there. So that is certainly an issue for us.
In terms of litigation, I mean, TIPs are relatively new, and I don't know that anyone's thought of holding up relatively smaller jurisdictions, so that's not, in terms of dealing with lawsuits from third parties, is really not an issue for tribes yet. I would say, with respect to timelines, tribes in general are always in favor of having deadlines or requirements that federal agencies get back. We've had a long history with other agencies, mostly in the Department of Interior, for delaying decision-making. So any putting the onus on federal agencies to get back timely and make decisions that we're always in support of.
Maybe I'll amend my answer to Representative Olson. I think a deadline or deemed approved on SIPs would be a great idea. I also think that the point made about lawsuits was a good one. I think there's a bill already passed by the House. I've read it. It's a great bill. Pass it again, or whatever the procedure is. Try to get the Senate to pass it. Try to get the President to sign it. I had to read in the paper the other day about a lawsuit that was filed not regarding Clean Air Act, but about nutrient trading under the Clean Water Act that was filed against EPA that impacts my state directly, and I might want to join that suit this time in favor of EPA to uphold nutrient trading in my state. The attorney's fees is another issue. The Equal Access to Justice Act has, I think, needs to be looked at in that regard. I'm not sure whether your bill that's already passed. I don't remember whether that does that or not. And ironically, as Martha was talking about the NSPS rules, and I think she's right. I think by and large, those were sort of they were passed. Nobody, the earth didn't end. A lot of those folks were doing green completions anyway. But that package was a product of a friendly lawsuit brought against EPA, and my state was frankly never brought into the loop on that matter.
Thank you. I certainly would agree that having a deadline for SIP approval, saying that SIPs would be automatically approved if they were not disapproved, I guess, or otherwise dealt with within a time frame, would certainly help. And I think, frankly, it would help with the lawsuits. Many of the lawsuits where we're left out are lawsuits over failure to approve a SIP. And so if the SIP were approved, you'd think that those lawsuits would largely go away. Maybe. I think that there are lots of groups out there that are pretty resourceful in coming up with claims against EPA or against the states if they don't get their way. I don't know if there's a way of avoiding that. And again, other than what I was commenting on before, if you can get groups together to sit around the table and collaborate on what makes the most sense, up front, I think you've got a better chance of avoiding challenges at the backside. And but I would agree that when EPA is involved in a lawsuit, that ultimately will affect a state either because of it will require program requirements for the state to expend resources, and the state is left out of that lawsuit. It is very troubling, I think, for the states. They need to be part of that discussion so that, again, there's a full understanding of what the impacts are, and they can play a role in whatever the settlement might be.
I certainly would echo that. I think on the SIP approvals, I think some kind of deadline that would be an automatic approval, like with a mutual extension, if there were really technical issues that a dialogue was going on, as opposed to it just sitting in an inbox somewhere, would be really appropriate, and it would help clean up the backlog. It would give regulatory certainty to the public about what the rules of the game are, so you don't have state rules that are adopted and at the state level being implemented and federal rules, the old SIP not being, that SIP not being approved into the federal rules, so there are really two sets of rules people have to live under. That would be very important. And on the citizen suit litigation, where those citizen suits involve commitments that states are going to have to do, like revise a SIP, it's just absolutely imperative. Think of that in reverse. If we were litigating, no two private parties can commit to a third party taking an action in a settlement of a lawsuit. And if it was if we were in a suit in state court, we certainly couldn't commit EPA to take some action by a set period of time without EPA's consent. So having these obligations, we get a phone call one day and say, you must have a SIP down to us by X date, without regard, and they may be settling it that might require 50 states to submit those SIPs, all of which have different rulemaking processes at the state level and regulatory boards, legislative oversight. Some may take 3 months to get through a system, some might take 1.5 years to act at the state level. So how EPA could even agree to a settlement of requiring a state to do something with all the variances that states have in their rulemaking process is crazy.
Not being a direct participant in the process, I defer to my colleagues on everything that has been said. I do echo that meeting deadlines and timely decision-making could help with the uncertainty, and so I would stop there.
Well, once again, thank you all very much, and we look forward to working with all of you as we move forward to continue to improve the environment and also promote economic growth. So that's a nice balancing act. So thank all of you, and if there's anything that you feel like we can be helpful with in a specific way, I hope you'll let us know. Thank you.
Thank you very much. I very much
See you.
enjoyed this.
Thanks, Michael. Great to see you. Thanks for being here.